appeal, part heard in the matter of standard life assurance and leave and others.
Thank you. Good morning.
Good morning, my lady. Thank you for your indulgence overnight. Unless the Tribunal has any questions for me, I have no further submissions to make.
My lord. No, thank you very
Thank you
much, Mr. Selby. Mr. Moran, good morning.
Good morning. May it please your ladyship and your lordships. In reply, I just want to address certain points that my learned friend submitted on in the order they were made, really. First of all, factors alleged to be relevant to the consideration of the viability of an extrapolated claim in a pleading, and reference was made to paragraph 65 of my learned friend's skeleton argument. I won't take the court back to it, but those propositions appear to be advanced simply in support of the proposition in the previous paragraph, 64 of the skeleton, namely that Standard Life's case appears to be merely that a sample need, and I quote, be linked to the pool in some way or form. In my submission, the factors that were referred to in paragraph 65 then go on to relate to the cogency of a sample as a matter of evidence. They do not address the base requirements of a viable pleaded case, namely the need to plead a cause of action and comply with the CPR. And that is because the factors referred to in paragraph 65 cannot be tested at the pleading stage, and secondly, the viability of the pleading, which is what we're concerned about, in terms of whether or not there are reasonable grounds for a claim, etc., is to be tested on the face of the pleading. Next, there was reference to Water Lily and there being no hard and fast rules as to how one pleads a contractor's loss and expense claim. It's unclear as to what relevance that submission has to this case. This is not a contractor's loss and expense claim. There are, of course, no hard and fast rules as to how one pleads anything, save, of course, the requirements to plead a cause of action and to satisfy the requirements of the CPR. Next, there was a query as to what BDP's case was on the viability of extrapolation claims in professional negligence cases. It's not BDP's case that a claim based on extrapolation could never, in principle, be viable in a Profnet case. This was explained in my submissions. The key point, however, whether or not one is considering a professional negligence claim, whether or not the claim is based on extrapolation or not, is that every pleading must firstly identify the cause of action relied upon, and secondly satisfy the CPR. In an extrapolation case, whether it's a professional negligence case or a defects case or whatever form of case, to satisfy those requirements, the pleading must refer to a sufficiently common alleged breach of contract or negligence and related kinds of similar work to make it viable in that sense. Now, in the defects cases that you've been referred to, satisfying that requirement on a pleading will be readily achievable because of the nature of the repeated breach of contract or defect and its repetition in the same kinds of works. Now, Amy is the case in point on that category of case. And just to emphasise this point, if I may just take you to Amy, which is in tab 7 of the authorities bundle. And if one turns to page, paragraph 1.17, which is at page 94 of the bundle, you see the judge said this: the majority of the patching and servicing claims are pleaded on the basis that Cumbria has examined a sample number of patching and surfacing undertaken by Amy, discovered various breaches of contract in relation to a number of those samples, and put forward its proposal for remedial works and costs by reference to those defective samples. Its claim is then pleaded and presented on the basis that the conclusion in relation to those defective samples can be extrapolated pro rata to the entirety of works of a similar nature. So that's the key distinguishing factor in what I may call the defects cases, where extrapolation is permitted as part of a pleading and in due course examined on the evidence. In a professional negligence case, that will be rarely possible because of the inevitably more diverse nature of the alleged defaults and the related work that it relates to. And this case is a choice example of that, because obviously BDP's supposed negligence, if it exists, would span nearly all the work categories in this large development over a long period of time in a large number of different ways. So it's at the complete other extreme to the sort of case that's been referred to in the authorities that have been presented to you that have dealt with extrapolation. Now, it could be conceivable, as we discussed in my submissions, in a simple case of professional negligence against an architect, one could satisfy the requirements to plead a cause of action and satisfy the CPR in relation to the extrapolated claim. We discussed the simple example of a postulated defective DPM in 100 houses, and essentially the criticism being you failed to inspect properly all of this work throughout all these houses. We'll focus on the first 5 to explain that in detail, and essentially that same breach or negligent conduct was replicated across the 100. So theoretically, one could conceive of the sort of professional negligence criticism that could be susceptible to be pleaded on the basis of extrapolation. But the present case is plainly at the other end of the spectrum, in fact in my submission, off the spectrum. It's simply not possible, and Standard Life has not even attempted to identify what specific criticism or even category of criticism, as summarised from Schedules 1 to 4, is alleged to apply to any individual variation in the list of the extrapolated variations, or even category of variations in the list of variations. The next point Malone and Friend made was that, building on his submissions in relation to extrapolation, that there was a suggestion that there's some inconsistency between BDP accepting that in principle extrapolation could be relied upon in a very simple professional negligence case, and at the same time relying on the dicta in Pantelli. Well, there is none. It just means that it will be very difficult to have a viable case on a pleading of extrapolation in a professional negligence claim against a construction professional. To do so, for fear of repeating myself, would require a common alleged breach applicable to the samples as well as to the pool that a claimant seeks to extrapolate into, and to the same type of work in the sample and the pool. The next point was that at various times it was suggested that Standard Life were in fact advancing in the pleading that this court is concerned with from January 2021, a more generalised case, that it was in fact suggesting some sort of comprehensible case on systemic breach, and that could save the extrapolated pleading that we're here to consider. Reference was made at various times to BDPs being at 6s and 7s, to quality control failures, inadequate resources, complete disarray. There was even reference to whatever may be in the latest, that's the 4th iteration of the Part B pleading served last week. Pleading served last week cannot be prayed in aid of a pleading served about a year ago that was the subject matter of this application, and it's the pleading that was considered by the judge in this application that's the relevant one. A case based on such broad criticisms anyway, such as you're at 6s or 7s, is not contained in the amended particular claim that we're looking at, and in any case, professional negligence claim anchored at such a high level of general criticism would itself be unviable. See Pantelli. Now, developing on that theme, Malone and Friend then took your lordships to various references in the amended particulars claim that we are concerned with, suggesting that there was some pleaded case of systemic breach beyond the mutatis mutandis further information paragraph, which we've already considered. And in short, the references Malone and Friend took you to do not do that. They are confined to the breaches alleged in Schedules 1 to 4. And I can take you to the first reference, it's paragraph 175 of the pleading, which is at page 804 of the third core bundle. My learned friend took your lordships to paragraph 175, and then in my note said words to the effect.
Sorry, which page?
804 of Core Bundle 3, paragraph
804.
175.
Yeah.
Paragraph 175 is 8 pages of generalised alleged breaches, all of which are in terms linked specifically then to the breaches particularised in Schedules 1 to 4. My learned friend, my note of what the submission was that...
You took us to this.
Yes, I took the court to this. And my learned friend went back to this and asserted, my note of what the submission was the breaches in 175 will be committed in the pool as much as the sample. And I think the suggestion was that paragraph 175 was somehow pleading a like breach in relation to the pool as well as the sample. Well, the short point is that paragraph 175 is limited on its face to the particular breaches specified in Schedules 1 to 4, i.e. the sample. There's no reference to it being applied to the pool in paragraph 175, let alone an explanation of how it is to be applied to the pool. If we move on to the next reference was to paragraph 182, subparagraph 3, which is at page 826, which is, I think, the only reference or use of the word systemic within the main body of the pleading. And again, my learned friend took you to paragraph 182, subparagraph 3, rather briefly, and I think my interpretation of the submission was that this was supposed to be a reference to where systemic breaches were being alleged that went into the pool. But one only has to look at the pleading to see that subparagraph 3 refers to systemic and recurring failings by the design team as the dominant or effective cause of the variations it has analysed, and over the page, the claims for loss and expense which it has settled. The variations which it has analysed are limited to the ones in Schedules 1 to 4. So this part of the pleading doesn't add anything to the only part of the pleadings that do purport to explain the case on breach as it's to be extrapolated into the extrapolated variations claim, namely the further information, the mutatis mutandis point. And I've made my submissions on how that point is incomprehensible, and that wasn't explained in the learned friend submissions. And then there was reference to paragraph 189, and moves on to page 828, and the Borough 4 document. Well, the Borough 4 document is not before this court, but I know that I'll be contradicted if there's an issue on this, but it doesn't take matters any further. There is no detail in it of any alleged basis for the criticism of BDP in relation to the extrapolated variations in the sense of explaining what the case on breach is. So the true position on the pleadings is the one that I summarised in my submissions. The only place where the case on breach in respect of the pool is pleaded is the mutatis mutandis averment in the further information. That, in my submission, is incomprehensible when applied to the extrapolated variations for the reasons I gave, and no attempt to be made to explain how that part of the pleading is supposed to work in explaining the underlying breaches of contract and negligence supposed to underlie the extrapolated variations claim. The next point of my learned friend submissions consisted of a reference to an invitation effectively to the defendants in the further information provided by the claimant for the defendants to propose ways to sample and present standard life's case. Well, it's obviously not for a defendant to do any such thing, especially when it is attacking the base viability of the pleading, as we all did in our defences, and where Standard Life has been given a chance to explain its case in the request for further information. But this suggestion that it's really up to Standard Life it's up to the defendants to go through the extracted variations and figure out what the case might be and then propose some sort of attempt to defend or prove a negative, appears to be part of a broader suggestion that is inconsistent, because the claimant seems to be saying, on the one hand, it's disproportionate to expect it to go to the trouble of actually looking at any of these variations and deciding whether there should be a claim, and if so, what it is. But at the same time, it seems to be suggested that as part of a defence to this kind of claim, the defendant can go away and be expected to research the very things that it suggested it's disproportionate for the claimant to do. In my respectful submission, that approach to life is turning the litigation process on its head. Then there was a submission that Schedules 1 to 4 contain, and my note of what the submission was, says very similar breaches. Well, we would invite the court to review Schedules 1 to 4, and one will see that that is plainly not the case. It's quite obvious. We're just looking at items 1 and 2 in Schedule 1. Item 1 relates to risers in residential apartments. Item 2 relates to floor screening to corridors. Inevitably, as is always the case in this kind of extensive construction dispute, the individual items are very fact-specific allegations of negligence. They're effectively individual claims. That's normally the case. It's also wrong of my own friend to suggest I didn't refer the court to categories A to D. I did refer the court to the categories A to D that the allegations in Schedules 1 to 4 can be compartmentalised into. But the fact that the allegations in Schedules 1 to 4 can be collated at a very high level into categories of allegations of late design, erroneous design, incomplete design, coordination breaches, is by the by. Any construction dispute can be categorised in such a way. However, an extrapolated claim to be viable in accordance with the CPR and present a comprehensible cause of action cannot be presented at such a high level of detail. Mr. Selby submitted, and this is again my note of what he said, what you see here is what you see there. What is that supposed to mean? How is that supposed to form a proper agenda for a trial? What you see here, I take that to be a reference to Schedules 1 to 4, is what you see there. I take that to be a reference to the extrapolated variations claim. What is it that we're seeing in the Schedules 1 to 4 that we're being asked to see in Schedules 1 to 4, in the extrapolated variations claim? If you can't be precise on individual variations, tell me at least the categories that the variations fall into. That's not even done. The next, and I think the main, one of the main submissions my learned friend made was that BDP does know the case it has to meet, and he made that submission in two ways. So I'm addressing BDP knows the case it has to meet, version 1. Reliance was placed on the context in which BDP received pleading, and Mr. Selby asked the court rhetorically, what can BDP be taken to know? And the suggestion appeared to be that BDP must well know the mischief or negligence that underlies the list of extrapolated variations. Quite an extraordinary submission in my submission. Of course, BDP is familiar with the variations in the list, but my gobbledygook submission was not aimed at that. It was aimed at the list being, in itself, an unintelligible basis on which to explain the case on breach of contract and negligence that's supposed to underlie those extrapolated variations. That is because there is no explanation of that at all. Standard Life, when making this submission that somehow all that's needed to inform BDP of the claim against it is the list of variations, also ignores a rather stark and important fact. This is not controversial. Over 50% of the contract sum in this case was made up of provisional sum items, 98% of which were undefined.
Sorry, 98% of it, I missed you.
Were undefined. So that,
undefined, sorry, yes.
So basically, a breeding ground necessarily for future variations, instructions to define what that work should consist of. This is explained in our skeleton of Section C. Inevitably, therefore, and I might add that's very unusual in my experience, and Lord Justice Coulson has more than me, that is a very unusual situation in a development of this scale. 50% of the work's undefined provisional sums. The significance of that is that it's inevitable there would be a raft of variations necessary simply to fill in the gaps into what the construction was supposed to consist of. And of course, instructed variations are part of a normal contract administrator's function anyway. No allowance is made for those two facts in the extrapolated variations claim. These points, of course, all feature in our defence to the claims. I mention them now simply to point out it's plainly wrong to suggest that somehow BDP can be taken for the purposes of understanding the pleading to know, simply from a list of the variations that were generated in this case, what that case might be. How can BDP possibly be expected to do that in the circumstance of this case, when Standard Life itself hasn't taken the trouble at this stage of the pleading process to do that exercise and explain its case? Now, that submission then morphed into a slightly wider one that Standard Life prayed in aid a shortage of information and documentation as somehow relevant to exculpating it from the state of its pleading. Mr. Selby went to an example of a CAI, which I won't take you back to, but the reference was in the supplemental bundle, tab 6, page 203, and he was criticising the detail of the information in it, if you recall. But then it became apparent that, notwithstanding those criticisms, that variation did form part of Schedule 1 and the particularised claim. It's at page 873 of tab 16. So this merely demonstrated that Standard Life, who was of course professionally advised throughout the works and as part of preparing its claim, could and should have done a similar exercise in respect of whatever variations it wanted to make a claim for, which of course is to a large extent, or a very large extent, what it did do after the order in this case in January 2021. And it managed to do that and whittle down the extrapolations claim to 5% of what it was when we sought to strike out this pleading, simply by analysing a further 110 variations, only 16 of which are now advanced against BDP. Now, BDP knows the case it has to beat, version 2, was based upon the submission that, and my note of the submission is literally, it can read, BDP can read, and the reference to the judge referring to the fact that BDP know the case it must meet, as if that's decided the issue that's the essential objection that we take to this pleading, as if that's been decided as a matter of fact. Obviously, anybody that can read can see that we are facing what we consider to be an unviable claim for an extrapolation exercise. To that extent, we understand the case that we are facing. Of course we do. What we don't know, and with respect, nobody in this room knows, is what is the alleged underlying breaches of contract and negligence relied upon to support the suggestion that there's been professional negligence in relation to the extrapolated variations that's generated a loss to the tune of £20 million. We don't know that because the claimant hasn't taken the trouble to even attempt to address it in its pleading, or even, at the date of this pleading, investigate if it may have a claim. So that is the essence of our objection, and plainly that, i.e., the cause of action underlying the extrapolated variation claim, is something not only we don't know, but at the date of this pleading, nobody knew. So if the judge was, well, it seems in my submission obvious what the judge was really referring to, us knowing what the extrapolated claim consisted of at a high level. But if the judge was referring to some unexpressed hidden knowledge on the part of BDP as to what the underlying breaches of contract and negligence really are in the extrapolated claim, he was plainly wrong. There was no evidence of any such knowledge. It was not an issue that he was being asked to decide. Loss and expense. I did, contrary to the submission made refer the court to how the loss of expense claim started by stripping out elements that Standard Life did not consider to be the design team responsibility. That's why I took the court to paragraphs 8 and 9 of the amended particular claim where that point is made. The point remains that ultimately the extrapolated loss and expense claim is merely based on an assessment by applying the 83.1% figure. That was the figure derived from the analysis of the 167 variations that were then whittled down to 122 to be included in Schedules 1 to 4. And then applying that to the sum of 10 million, which was the loss of expense claim after the extraction of money that Standard Life was conceding was not the responsibility of the design team, less the 6 million that was claimed as a direct loss and expense claim, the conventional loss and expense claim. So it was an assessment, 83.1% applied to about 4 million. No identification of what loss and expense heads were being claimed, or of any individual extrapolated variation or category of variations that have caused that. Just a bald assessment. Next, there's the issue of the relevance of the considerations of proportionality to a pleading, and Mr. Sedley took you to paragraph 45 of my skeleton, but without referring you to paragraph 46 of my skeleton, which makes clear, as I submitted orally, that what we say, that we say the consideration of proportionality is not relevant to the first stage of the two-stage test that arises on a strikeout application. I do not submit that proportionality can never be relevant to an assessment of adequacy of pleadings by a court. Obviously it can.
Sorry, you don't submit?
I don't submit that proportionality issues are never relevant to the consideration of a pleading. Take, for example, an application for a request for further information. A court might decide that the claim is adequately pleaded. It would be disproportionate to go to the nth level of detail, that sort of issue. My submission in relation to the irrelevance of proportionality is linked specifically to the issue that this court is considering, namely the proper approach to a test for a strikeout. And the proper test to the approach for a strikeout is a two-stage test. The first stage, based merely on an assessment of the pleadings, just reading the pleadings. Proportionality, my submission, does not come into it there. I made my submissions on that. If you haven't pleaded a cause of action, you can't turn around and say, well, it will be too expensive for me to do so. I nevertheless want to claim my £20 million. It's an objective assessment of whether the pleading discloses a cause of action and complies with the CPR. Proportionality then would become relevant to the exercise of the discretion of the court if it was found that there wasn't a viable pleading. So take, for example, a litigant in person coming to the court and presenting a modelled claim that doesn't disclose a cause of action, but plainly there is some bona fide complaint and for lack of resources and time hasn't pleaded the case properly. The court would then find that there isn't a viable claim pleaded, but in the exercise of its discretion, it might say, well, I'm not going to strike it out because of all the circumstances and proportionality and the rest of it. That's where proportionality comes in the second stage.
Does it? I have trouble with that submission, because if you decided it's an abusive process, then it's up to the court to decide what to do about the abusive process. And that's an exercise of discretion.
Yes.
And that will then depend on all the factors. But that's not really proportionality, is it?
Well, it may or may not be, but my submission is...
Well, it would be barely of relevance, let's say. I mean, if you say it's not relevant to the first stage at all, then if that were right, it's difficult to see that it would actually make any meaningful difference.
Well, it would depend on the circumstances. And
Well, it would always depend.
An extreme example. But you're right, in this sort of case, we've got commercial parties, and if
I mean, if you have an abusive process, the court usually says, you've got 10 days to do this, that, and the other, or the claim is struck out.
Well, it might say you can, if the abuse, it depends what the abuse, but if the abuse was an incoherent pleading, say, from a litigant in person, say, the court might say, well, look, this is an unviable pleading,
And you've got 10 days to sort it out.
You've got time to sort it out. You've got to provide further particulars, whatever.
You don't take into account proportionality.
Well,
you just get it by the scruff of the neck.
Well, you may.
If it's an abuse.
Well, you may or may not. I mean, I think the court may say, well, look, given the circumstances, I want you to plead your case in a certain way, but I don't want you to give the nth degree of detail, just enough for the defendant. So a proportionality issue becomes relevant. But the key submission is, for the purpose of a strikeout application, the first stage doesn't generate issues of proportionality because it's no answer to a pleading that doesn't disclose a cause of action that, well, it would be disproportionate in terms of time and money for me to take the trouble to do so. It just doesn't disclose a cause of action. If there is a relevance of proportionality in terms of what the court does about that, it comes in the second stage, which is whether or not the court then strikes it out or whether or not the court decides to do something else. But in my submission, the proportionality issue isn't one that can dictate the answer to the first question, which is, does this pleading disclose a cause of action or a claim that complies with the CPR? Because a claimant could not pray an aid proportionality to excuse the failure to plead a cause of action. It can pray an aid proportionality and all sorts of other things when it comes to the court does about that. And that relates to one of our criticisms of the judge, in that by looking at it in a unitary way, the court has effectively missed the significance of the pleading on its face being unviable. Because, of course, in a case like this, where you've got commercial parties with no issues in terms of financing and preparing claims, it's difficult to understand if one reaches the conclusion that the pleading is unviable, and having regard to the fact of what happened in the 6 months after the strikeout application in terms of developing the pleading, it's difficult to understand how the inevitable consequence of the unviable pleading prima facie being struck out would be deviated from on issues of proportionality in this case. That leads us to the final point, and perhaps the final submission, no, two final submissions, perhaps the two most important points for this court to bear in mind when it decides this case, because, well, for reasons I'll explain. The first was that it was suggested that it cannot be said that there's no reasonable basis for making the postulated inference that lies at the heart of the extrapolated claim. And that was a apposite reminder to the court that this was an application not just for strikeout, but for summary judgment. So the question that arose in the context of summary judgment, whatever one might decide in terms of the viability of the pleading, the question that arises on the summary judgment is, does the claimant have a real prospect of succeeding on its extrapolation claim? I.e., let's assume that fault could be established as alleged in all 122 of the Schedule 1 to 4 variations. Is there, on the evidence that's available in the pleading, a realistic prospect that Standard Life could succeed in getting a court to infer that negligence, to the same extent and value, 83.1%, across all of the remaining variation account occurred, even though, one, there was no explanation of what precisely that negligence consisted of in the extrapolated variation account. Two, the relatively small number of the pool, 122 versus 3,000 plus. Three, the relatively small value of the pool, 3 million versus the extrapolated claim. Four, the different categories of work in the pool compared to the extrapolated variation account. Five, the absence of a pleaded connection to identify what the breaches categories, what the individual breaches or even categories of breach were supposed to have been as replicated in the extrapolated variations. Sixth, the huge amount of provisional sum items that would have necessitated variations in any event. Seventh, the other possible explanation for instructed variations in the normal course of a construction project. 8, the absence of any expert evidence to support culpability in relation to the work that's connected with the extrapolated variations. In my submission, respectfully, there would be...
I'm so sorry, Mr. Brand. I missed number... Well, can you remind me of your points 2, 3 and 4 again? I think I've got 2, but I just want to... I have missed one of them.
But yeah, I went off piste in terms of my list, so I'm going to have to...
Yeah, so I
relatively small number in the pool.
Yeah.
Relatively small value of the pool compared to the extrapolated.
That's the one I missed.
Of the sample compared to the pool. The different categories of work in the sample compared to the pool.
Got it.
Absence of a pleaded connection.
Yeah, I've got it.
Okay.
Got it. It was just it's actually the third one I missed, not before.
And of course, there could, for the purpose of summary judgment, there could be no evidence adduced by Standard Life to say, well, look, here's my expert evidence to tell you why we're going to say, as a matter of fact, you can infer from the Schedules 1 to 4 criticisms culpability in some unexplained way. Of course, you couldn't do that because nobody could do that, and because Standard Life hadn't even looked at them. In my respective submission, in those circumstances, there is no realistic chance of a court making such an inference in Standard Life's favour. And Mr. Selby made some strange submissions in my submission in an attempt to postulate some factual connection between the categories of work. But none of those are pleaded, of course, but none of them would get over the factors I've just listed. It's inconceivable in my submission, looking at this claim, that any court would infer unidentified negligence to this extent, in a case of this kind, on the basis of 122 pleaded examples in other categories of work. There's no authority that I'm aware of liability being established in this way in any professional negligence context, let alone a construction claim, which is inevitably consisting of multifarious types of work and types of potential breaches and types of potential excuses for failing. And that is a point that is important. This was a summary judgment application as well as a strikeout. And the suggestion there was any chance at all of this claim being established on the evidence available is or near or at 0 in my submission. And finally, and just as importantly, the floodgates argument. Mr. Selby, of course, inevitably poo-poos this. But in my submission, in order for this court to support the extrapolated claim in this case as being viable, this court would need to do one of 2 things. First, find that the alleged basis for the underlying breaches of contract negligence related to the extrapolated variation claim variations are adequately pleaded. And that would be in spite of no one being able to identify what the breaches are. Or this court would have to find that it does not matter that this pleading does not do this. In my submission, in either event, the court, if it was to do so, would then be recasting how professional negligence claims, especially construction claims, may be presented and pursued. This would raise a matter of public importance well beyond the significance of the point in the present case. My Lord Justice Coulson has more experience of the vagaries and enthusiasm of the construction claims industry. But in my submission, it would inevitably, if this form of pleading were to be acceptable to the Court of Appeal, it would inevitably lead to a change in the construction claims industry's approach to such claims, not just professional negligence claims, but defects claims as well. Why, one might ask, would a contractor have to set out its case on breaches or defects or delay events in Scott schedules anymore? Why not just pick what you say is a representative sample of what you're complaining about, and then assert that you can extrapolate that into the pool, an undefined pool perhaps, or even a defined pool, and automatically multiply your claim by a factor of 10, 20, 30. You can then refer to the Court of Appeal's decision in Standard Life and say, well, it all depends upon the facts. We can sort this all out at trial. In the meantime, put unacceptable pressure on defendants and their insurance. And why stop at construction negligence? What about the barrister who's perhaps asked to advise on the merits of Schedules 1 to 4, and then a week later asked to advise on the merits of the extrapolated claim? He advises on the merits of Schedules 1 to 4, and that leads to the claimant undersettling those claims. And the claimant then says, well, Mr. Barrister, your negligent advice led me to undersettle those claims. And this is why I say you were negligent. These are the criticisms. This is the advice you should have given me. Had you done so, I would have acted in the following way. Had that happened, I would have achieved a better settlement. A conventional barrister's negligence claim. Oh, and by the way, Mr. Barrister, I've got a second claim for you. It's to do with the parallel advice you gave a week later on the extrapolated variation claims, the one for an awful lot more money. I'm going to allege that you were negligent in relation to that as well, but I'm not going to tell you how. I'm going to infer that you were negligent because of the established negligence on your advice in Schedules 1 to 4. And more than that, I'm going to quantify the loss that's caused me by reference to the proportionate undersettlement of the claims in Schedules 1 to 4. And I'm going to plead that out, and any court in which that is challenged being unviable extrapolation, I'm going to refer to the decision of the Court of Appeal and Standard Life. And I'm going to say this is just a development of a novel area of the law of extrapolated claims, and we don't need to tell you why you were negligent in relation to the extrapolated claims advice, because we can infer that. Must have been roughly similar to the sort of approach you took, because you're that sort of negligent barrister type, aren't you? We've demonstrated that in Schedules 1 to 4. If one translates the principle at the heart of this appeal into other professional contexts, in my submission, the unviability of the approach becomes obvious. All that makes it slightly less obvious in this case is because it's one of these construction disputes with many lever arch files, very long pleadings, very wordy explanation. But at its heart, it's a very simple point. One can't, under the smoke screen of an extrapolated claim, introduce claims that do not have a coherently formulated cause of action expressed on the pleadings that can be understood by the court and the defendant. Because if you do, you don't just encourage this sort of spurious claim, extrapolate just to put pressure on the defendant. You lead to the real possibility, a point that I don't think my learned friend answered, which is that you are postulating a situation where if this matter went to trial and succeeded as it's been pleaded, a defendant would end up paying damages in relation to, in this case, the extrapolated variations claim, for defaults in relation to the extrapolated variations claim that no one ever explained to him. That's not just unjust, that's just patently absurd in my submission. And that is the mischief at the heart of this pleading. When one cuts through the thicket and when the smoke clears, that is the essential point. And it's for that reason this pleading, the extrapolated elements of it, should have been struck out or summary judgment entered in respect of them. And it's for that reason that the Court of Appeal should now rectify that on this appeal. So those are my submissions.
Thank you very much. Anything further? Thank you, Mr. Moran. We'll obviously reserve. Drafts will be sent in the usual way for identification of any typographical errors. No further legal arguments will be entertained unless specifically invited. It will be handed down remotely, and in those circumstances, if there are any ancillary applications, they can be notified in writing. Obviously, we would ask that the parties agree the contents of the order and submit it with their suggested edits, if there are any. All right. Thank you both very much, and obviously we also thank Mr. Webb and also Mr. Monroe Morrison and the solicitors. Thank you all very much.